stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. Yes, I am your host this hour and also next hour here on all of the broadcast stations of Civic Media. As always, honored and delighted that you have chosen to spend some portion of your weekend in conversation, in discussion with me about those important, significant rule of law events, those current events in the areas of justice and the aspiration for it in America and beyond. We take our name, as always, Amicus, from the legal word, also the Latin word that means friend, sometimes friends of the court when it's joined with the phrase amicus curiae. The notion is analysis, deliberation, consideration, advice, counsel that somehow animates important decisions being made most often by a court. Could be a trial court, could be an appellate court. Most often the United States Supreme Court is where the word amicus comes from. We take our name from that notion in the concept, in the hope that we are also providing you as our friends with some information, some insights and perspectives that assist you in understanding and appreciating and assessing the world in which we live, focusing once again on those major stories in government and the rule of law. As always, as a part of that discussion, my terrific producer Max and I invite you to be a part of our discussion this weekend at that phone number. That is 855-752-4842. That number is once again 855-752-4842. Be a part of our discussion by calling in. You can also drop a comment, a question, an inquiry, an observation into the chat line here at Civic Media, and we will also make those comments, those observations a part of our weekend program. Once again, Amicus, a law review, beginning now and continuing this hour and next hour. There is, as always, an awful lot to get to, a week chock full of important news and events in the areas of rule of law, and certainly at this momentous, very significant time in the history of our nation, and yes, indeed, our world. Lots of things to look forward to in terms of understanding, comprehending what is about to happen in America, and appreciating some of those things that can and cannot happen, and those kinds of issues. That kind of focus animates in many ways our syllabus this weekend on Amicus Law Review. Let me tell you a little bit about the kinds of things that we're going to be discussing this hour and next hour. Plainly on Monday of this week, January 20th. Yes, it is constitutional that we swear in a president at this time. And so on Monday, just a few hours from now, the next president of the United States of America, his name is Donald John Trump, is going to be sworn in. Now no longer on the western steps of the Capitol building, as has been tradition, with some changes, with some aberrations. Way back in 1985, also when Ronald Reagan was being sworn in, they also went indoors because of the cold weather there in that southern city called Washington, D.C. Likewise, this coming Monday, we are not going to be seeing the inauguration, all of the pomp and circumstance that goes along with that outside the Capitol. We're going to go inside the Capitol, to the Rotunda. The events going to be changed in venue, but not in terms of significance. And so we're going to talk about the meaning and application of that. In particular, we're going to focus on the oath of office that incoming President Trump is going to be taking, as have all of his predecessors in our terrific, great nation. And we're going to focus in particular upon the oath of office that requires that he abide by and support and defend and protect the thing called the Constitution of the United States of America, focusing with even more detail on a particular provision of Article 2 of the Constitution called the Take Care Clause. The Take Care Clause, talking about what that says, what it means, what it's meant historically, and why it is so significant for every president, but especially this president, as we think about the things that may happen in the coming administration of Donald Trump. The importance of understanding that the oath includes the obligation of any incoming executive to take care that the laws of our nation be faithfully executed. all that language we're going to be pulling apart and dissecting, talking about that particular provision as we go into the inauguration of just hours ahead. Second, much related to that, talking about something else that happened late this past week when the current president, his name is Joseph Biden, decided to adopt and articulate his view that we now have a 28th Amendment to the United States Constitution. Up until now, 27 amendments to the Constitution. Many others proposed at the time of the first Congress, and since then, the 28th Amendment, according to our present President, Joseph Biden, called the Equal Rights Amendment. The Equal Rights Amendment, we'll talk about what that says. We'll talk about what he did and what he did not do. Some advocacy from me about what he should do to ensure that 28th Amendment, protecting the rights of women in all areas of life and livelihood in the United States of America, is codified as a part of our Constitution. Question is, do we have a 28th Amendment? And controversy, of course, still surrounding that, even in the wake of the president's articulation of the view that all of the necessary prerequisites in terms of state ratifications have been put in place. And yet there is a singular but critically important event that has to do with the archivists of the United States of America that has not happened, that may have an awful lot of printers, an awful lot of civics teachers around the nation scratching their heads about whether or not, as we go into this new administration, we have 27 or 28 amendments to the Constitution. Of course, that follows another significant, what I have always maintained, is another significant amendment to our Constitution that happened less than 7 months ago when the United States Supreme Court articulated a position, a view also about the second article of the Constitution, that is the presidency, the powers of the executive branch, and articulated not only a super powerful, a super strong executive that we have not seen before in our nation, also, of course, establishing that person, whoever occupies that position in the White House, in the Oval Office, in the West Wing, not only has incredible powers beyond those of the other branches of government, legislative and judicial, but also has immunities for things that she or he may do in that office. A stunning, yes, indeed, amendment by the Constitution of the Constitution by the Supreme Court of the United States of America that on July 1 of last year. Lots of things going on with our Constitution. Of course, the Supreme Court necessarily looms large. We're going to talk about Supreme Court updates, that big event just late this past week, in which the Supreme Court upheld unanimously 9 members of our Supreme Court supporting, endorsing, and finding legitimate the decision by our legislature, our Congress, the House of Representatives, and the Senate of the Congress, passing bipartisan legislation signed by President Biden, now the law of the land that says that TikTok needs to go out of business. By when? By the 19th of January. That is this weekend. We're going to talk about what the Supreme Court did unanimously to support that decision, that legislative enactment by our Congress that brings an end to TikTok in America, unless there is a buyer for TikTok that takes it out from under the supervision and control and corporate status underneath a Chinese organization, also beholden to the Chinese government. That's the concern that animated the Congress, the safety and security of all of our people via TikTok. No small event. TikTok going dark this weekend in the wake of the Supreme Court's major decision of just late this past week. And of course, that also raises an awful lot of issues about, once again, the Take Care Clause, because it happens to be going into effect just as a new president who has said he will save TikTok. He wants to keep TikTok alive. What is his obligation now under the Take Care Clause to enforce that law that's now been upheld by the Supreme Court? We'll talk about all of those things in connection with the ban on TikTok in the United States of America. We'll talk about some of the major cases argued before the Supreme Court just this past week. Those are cases with the names of Hewitt and Thompson and Paxton and Stanley, all kinds of cases out there. We'll be focusing on two of them having to do with the imposition of sentences, federal criminal sentences upon people who are engaged in the trafficking of narcotics, scheduled substances in our nation. Hewitt having to do with a thing called retroactivity. You get the benefit of a change in the law by the Congress by virtue of the timing of your sentencing. A lot to unpack there. And inside that particular oral argument, inside that issue about the applicability of something called the First Step Act, we recognize as well that in addition to all the other things that President Biden has been doing recently, he issued more pardons this past week, 2,500 of them for nonviolent drug offenders. We'll talk about that as well. Lots of criminal law, criminal prosecution, criminal litigation in the news of our nation here on our broadcast. And then another major oral argument of just this past week. There's a case called Free Speech versus Paxton. And yes, indeed, it's a First Amendment case involving the attempt legislatively by states to require that there be age verification on online access, basically attempting to ensure that youth are not exposed to certain types of adult presentations, adult postings online. Can they do that? Is that, like the TikTok matter, is that a violation of the First Amendment, or is there a legitimate state interest in ensuring that young people, minors, MINORS, do not have access to those kinds of things? That was the oral argument also engaged in by the Supreme Court just this past week. We'll talk about that in addition to the upcoming cases next week, a couple of them also very significant as the Supreme Court pursues right now 56 cases on its docket. Probably adding a few more. And then we're going to talk also about the other major news of this past week having to do with that special counsel report finally issued. At least half of the special counsel report issued. This is Jack Smith telling us what might have been in that prosecution coming out of the Justice Department. Finishing up in our broadcast about an issue on what judges can do under the Constitution, all of that coming up here on our weekend edition of Amicus, a Law Review. All right. So Mark's already on the phone. Okay. Yeah. I will not get, you can tell him I won't get to him maybe late this hour, but more likely maybe next hour. We'll see. But okay. We had, for what it's worth, it was odd, not odd, but it was positively odd. I think we had 9 callers last week. It's amazing. So
maybe they just don't like me.
Well, no, I don't know. I made reference to you, obviously not to you being gone, but to Greg, of course, but I don't think it has anything to do with that, my friend. But anyway, maybe it was the subject matter. Maybe people are just inside and listening to the radio. But so anyway, good. We're all set to go here. Good.
Sounds good. About 20 seconds.
Good. My name is Jim Santelle, and I am your host for this broadcast of Civic Media.
We call ourselves Amicus, a Law Review, friends of yours, providing insight, some set of counsel, some understanding, some appreciation for the major news events of our time, focusing in particular upon the rule of law and justice. Lots of things necessarily focusing upon our Constitution and government, the federal government, the state government as well. We know, of course, that on Monday, the 20th of January, a major event in American history. It happens every 4 years, sometimes, occasionally, more frequently when we have an early departure, either by resignation, that happened once, or death of a president. But we know that this coming Monday, Donald Trump is going to be taking the oath of office as our next president, swearing in front of all of us to observe, to support, to defend, and keep in place the Constitution of the United States of America as it exists right now. Again, we're going to get to this issue about whether or not we have a 28th Amendment as the Biden administration comes to an end and the Trump administration begins. That up for a bit of discussion in American politics and government and law. But right now, we're focusing upon this requirement that we impose upon any incoming president, that he, one day she, abides by the laws of our nation. And so indeed, we're going to spend some time talking about Article 2 of the Constitution. That, of course, is the second article of our major founding document that still should animate all that we do. It is the article that prescribes the powers and the duties of the executive branch. We know it as the presidency. Article 1, of course, the legislature. Article 3, the judiciary. And then articles beyond that. Article 2, Section 3 of the Constitution both grants and it also constrains presidential power in ways big and small. The section invests in the president the discretion to convene Congress on extraordinary occasions. That's the way that James Madison described it. A power that has been used to call the chambers to consider nominations and declarations of war and some other types of emergency legislation. That same section, Section 3 of Article 2, also grants the president, the executive branch, the authority to adjourn Congress whenever the chambers cannot agree when to adjourn, a power that no president has ever exercised, but it's there. Section 3 also imposes obligations on our president. Once again, that's what we expect of the president, that are varied and they're significant. It is a grab bag of all kinds of things put together in one paragraph. The president, according to Section 3 of Article 2, must provide information on the state of the union from time to time. That obviously we see every year as a president stands in the well of Congress and delivers a report to the Congress on the state of the union, and also plainly advocates for his, maybe one day her, policies, practices, things she or he wants to get done. We have seen that. It is constitutional nature. It is required that we do that. And this seems to require that the president share information with the Congress. That plainly is done routinely through the sharing of information of the both branches of government. In that connection, the Constitution directs that the president shall recommend measures to Congress, plainly proposing certain kinds of legislation. President himself, herself does not have a vote, although arguably could be, has been the case, and in some instances, the vice president, as the president of the Senate, sometimes breaks log jams, does vote on legislation, but the president himself, herself, is required, obliged under the Constitution to provide recommendations, measures that the Congress should consider. That happens with some routine frequency, even though it's the Congress that puts together our legislation, sponsors it, votes on it, has hearings on it, all those kinds of things. Also, the president shall receive foreign ambassadors, a duty that many believe grants presidents the authority over whether to recognize foreign nations and their governments, a huge amount of overseas international authority. The president also shall commission all the officers of the United States. That's a clause that plainly forces the president to authenticate the status of federal officials. No small thing. We'll chat about one invocation of that. But most importantly, and the reason why we're focusing here on Amicus, on Section 3 of Article 2 of the Constitution, is the language in that section called the Faithful Execution Clause. The Faithful Execution Clause is commonly known as the Take Care Clause of our Constitution. It is a major source of presidential power. Some say it's perhaps the most important source of presidential power because it seemingly invests the office with broad enforcement authority. At the same time, and this is its other sort of bifurcated aspect, the provision also serves as a limitation on that power that is expressed in the Constitution because it underscores this notion that our president, the executive, is under a duty to us. And yes, indeed, she serves us in that role, is obliged to faithfully execute the laws of Congress and not disregard them. That is no small thing. The Take Care Clause of the Constitution has played a major role in momentous constitutional disputes. Legislators discuss it all the time. It shows up in the congressional record. It animates in ways big and small virtually everything that Congress does because, of course, the Congress passes the laws. Who executes the laws? That's the executive branch. That's the president. And so when the Constitution says that the president is obliged to take care that the laws of the United States be faithfully executed, that's the implementation portion. That's the vesting of great authority in the presidency, but also limitation, that two-aspect approach to understanding the Take Care Clause. Legislatures, again, in the past, legislators of our contemporary time understand well that language posits in the president a huge amount of power, but also limitation. And they write their legislation around that. A lot of our legislation is premised upon that understanding, of course, that the legislation will not only invest the president with power to do things, but also to do it in certain ways. And we've had a lot of discussions here on Amicus, a law review, about that issue. The extent to which legislation can and should be specific or broad in nature. It is no doubt significant that two of our presidents who have been impeached, Andrew Johnson and William Jefferson Clinton, were impeached by the House, at least in part for allegedly violating their Take Care Clause duties, taking care that the country, the laws of our nation be faithfully executed. It is certainly implicit in the times that the Congress impeached President Trump, that likewise that Take Care Clause was underneath, if not at the top of the discussion. It is interesting to note as well that there are some major Supreme Court cases like Youngstown Sheet and Tube versus Sawyer, 1952, and Myers versus United States in 1926. They relied upon invocations of that clause. Let me give you a little bit of a sense of what those cases are all about. I suspect you may know about at least the first one of them, Youngstown Sheet and Tube Company versus Sawyer. This is back in 1952, a landmark case coming out of the Supreme Court, limiting the power under the Take Care Clause of the President of the United States of America to seize property. The case was a check on some of the far-reaching claims of executive power being exercised at that time by President Harry Truman during the Korean War. As we continue, we'll talk more about those cases and then talk about why the Take Care Clause historically has been important and why it is important as we inaugurate a new president to understand what it says, what it doesn't say. All of that here on Amicus, a law review. Amicus Law Review. My name is Jim Santelle. I'm your host this hour and next hour, also here on the broadcast stations of Civic Media. Thank you for joining me this weekend as we talk about matters related to the investiture, the inauguration of presidents in America, including the oath of office that every president, including soon Donald Trump, takes to support and defend and uphold the Constitution, including the Take Care Clause inside of Article 2, Section 3 of the Constitution that simply says that he, the president, shall take care, capital C, that the laws, capital L, be faithfully executed. That's the Take Care Clause. It is not very expansive. And so the Congress, implementing that, passes legislation. And yes, indeed, presidents act also under that, both in terms of exercises of power, vesting in them authority to act, but also limitations on that power. And then we've had United States Supreme Court panels that have said that the implications of that Take Care Clause variously support and defend, and support and indicate that the president cannot act in certain ways. One of those back in 1952, Youngstown Sheet and Tube versus Sawyer. In the midst of the Korean War, the United States Steel Workers of America threatened to strike, and they were looking for higher wages at the time. They were striking against a major steel producers in the United States of America. The president at that time, of course, Harry Truman, believed that a strike of any length would cause severe dislocations for defense contractors, and he seized control of those production facilities. You sometimes forget about that history. He seized control of them, keeping them running and ensuring that the plants themselves were producing the products necessary to support the war. The challenge by the president is against that action, of course. And the United States Supreme Court, in a major opinion, Associate Justice Hugo Black held that the president lacked the power to seize those steel mills in the absence of statutory authority, only able to engage in this kind of conduct with express statutory authority conferred on him by Congress. Again, taking care that the laws, capital L, be enforced in our nation. And that case to this day stands as a check under the Take Care Clause that may, in fact, as it is in all administrations, may in fact loom large as we think about the things that the incoming president may or may not do in his exercise of authority to take care that laws be faithfully executed. Similarly, decades before, a case called Meyer versus United States, going in the opposite direction here, saying that the Take Care Clause, the Constitution, permits the executive, the president, to act as he did. Major Supreme Court case. The president has the exclusive power to remove executive branch officials, does not need the approval of the Senate or any other legislative body. There were some later cases, 1935 and even in 2020, having to do with the same issue. In 1920, however, a person named Frank Myers, first-class postmaster in Portland, Oregon, was removed from office by President Woodrow Wilson. An 1876 federal law provided that postmasters of the first, second, and third classes shall be appointed and may be removed by the president with the advice of the Senate. Myers argued that his dismissal then by the president at that time was unconstitutional. The Chief Justice and former president, for what it's worth, William Howard Taft, writing for the court, said the Constitution mentions the appointment of officials but is silent on their dismissal, permits the current president at that time to go ahead and provides not so much a check, but an affirmation of the authority of the White House to act. Two very important cases under the Take Care Clause, indicating once again that these things do indeed get into the courts, a point we'll talk about in greater detail in just a moment. Recently, the Take Care Clause has provided a lot of grist for discussion, for debate in our Congress and beyond about the authority of presidents generally to act. President Obama, very notably, invoking that, people invoking it on the other side in connection with the enforcement of federal immigration laws. So where does this come from? Where do we get this notion of a president taking care that laws be faithfully executed? Way back in the 1776 period of time, the 1776 Pennsylvania Constitution, the 1777 New York Constitution, both granted the executive some power, but also required them to execute the laws faithfully. Again, that bifurcated notion, we're giving you the authority to act, but you've also got to do it faithfully. And that's in our Constitution as well. Early constitutional decisions shed some light on the meaning. The clause, of course, is found amidst this sea of many other obligations there. Interestingly, Alexander Hamilton looked inside all of those powers and spoke about the power of faithfully executing the laws because it was set forth amidst all of the other grants of power to the president. George Washington, maybe going in the opposite direction at the time, talked about the limits of his capacity to act. He said, "It is my duty to see that the laws are executed. To permit them to be trampled upon with impunity would be repugnant to that duty." So we've got, from the early times in our nation, some disagreement about whether it's about power or about limitations on that. All of that, of course, leading to the notion that modern presidents, including President Joe Biden right now, incoming President Donald Trump, are obliged, and they take the office understanding that they've got this obligation to take care that the laws be faithfully executed. And so why do we talk about it? Why do we talk about it this week in connection with issues related to current events and also the administration of law in America? Because as in all administrations of every ilk, every certain color, every certain invocation, all administrations need to be mindful of this incredible power, but also the limits on it. And if indeed there are pieces of litigation, if there is civil litigation, if there is criminal litigation of certain kinds, to address things that are done by this president, by any president, if there are actions in the federal district courts, the appellate courts, ultimately in the Supreme Court, every so often, federal issues do in fact show up in the state courts of our nation. In all of those pieces of litigation, arguably challenging things that a president may do in the coming days, weeks, months, and years, as has been the tradition in our nation for all previous presidents, including Joe Biden, including Donald Trump in his first term, including Barack Obama, including all the presidents who have preceded those presidents on all sides of the political aisle. This notion of executing the laws faithfully has shown up in the litigation, in the civil complaints filed either to address, to challenge, to somehow push back on things that the executive branch may be doing. It is argued quite literally in the federal district courts, the appellate courts, and yes, indeed, the Supreme Court of our land. That is why, when President Trump takes the oath of office on Monday, it is so very important to understand that he is also committing to faithfully execute the laws. Yes, indeed, he has power to do it, but there are also limitations on those powers. And it is that argument, if you will, about which one of those aspects of the take care clause, the vesting of power or the limitations of it, holds sway in any particular attack upon, challenge to what a president, including Donald Trump, may do. It is important for Americans to understand, even if they agree, if they disagree with what the incoming administration, past administrations have done, that all of that centers ultimately upon the Constitution, authorities given there. And yes, indeed, at the risk of overstating the importance of this, the president's authority comes from that take care clause. Whether or not he, one day she, is violating it, plainly the subject of an awful lot of debate among Americans. That's a good thing. That's what we embrace under the First Amendment, but also litigation. And it is to be assumed that in the days following Donald Trump's inauguration, as he returns to the White House for a second term as our chief executive, he will do things that will prompt people to challenge those kinds of actions. We know what those are. We'll talk about them down the road on this broadcast, certainly other broadcasts of civic media as well, in the areas of, yes, perhaps at the top of the list, immigration, but also healthcare and commerce and things related to basic human rights, civil rights, housing, voting, all kinds of things that are important to our nation, agriculture, commerce, all kinds of things that animate who we do, who we are, and what we do on a regular basis here in our nation. And so the Take Care Clause looms large. And although probably not mentioned by a lot of the commentators on Monday who are providing us with other instruction and other information about what's going on in the rotunda of the Capitol, still animated by the Take Care Clause of the Constitution, that's what it is all about. One of the things, of course, that a president can do, not without controversy, not without people running into courts to address it, to challenge it, is issue executive orders. Now, just this past week, late this past week, President Biden did issue an executive order, which may be part of the point of this, but he declared on Friday that he believes, based upon his assessment, and yes, indeed, an awful lot of support out there, that the Equal Rights Amendment has met the requirements of ratification and therefore is now a part of our Constitution, becoming the 28th Amendment to our United States Constitution. What does that amendment say now, 28? It says just this: equality of rights under the law shall not be denied or abridged by the United States by any state on account of sex. And that word sex, of course, has loomed large. Plainly, the Equal Rights Amendment, authored, as we'll indicate in just a few moments, many decades ago, almost 100 years ago initially proposed, nonetheless focuses upon ensuring that women in America, and candidly of all gender identifications, that word sex now being interpreted according to the Supreme Court, a case called Bostock, giving it great latitude under Title VII, enforcing and ensuring that civil rights for all people are observed, including women in America. And that's what the Equal Rights Amendment has been all about. President Biden said this. He said, "In keeping with my oath and duty to Constitution and country, I affirm what I believe and what 3/4 of the states have ratified." That's the basis upon which he has said, yes, indeed, it is now a part of our Constitution. He said the 28th Amendment is the law of the land, guaranteeing all Americans equal rights and protections under the law, regardless of their sex. Under the Constitution, however, and this is where it gets tricky and complicated, the president has no direct role, of course, in approving amendments, and his statement alone, just that, has no legal force. It is the archivist of the United States, who's a Biden appointee, who has refused up to this time to formally publish the amendment on the grounds that it has not met the requirements to become a part of the law. The situation here is that President Biden has chosen not to order the archivist, her name is Colleen Shogan, Shogan, to reverse her position and publish the amendment as advocates have urged him to do. The Archives Office, nonetheless, has said that in their view, the requisite number of states have not endorsed this. Even so, advocates have maintained that Joe Biden's imprimatur on this amendment give it additional credibility going forth in any future court battle, whether it actually has the force of law or not. Again, the amendment guarantees equality for women in all facets of life, including pay, including housing, including all those other things, a constitutional guarantee against sex discrimination. Needless to say, a lot of people resurrected efforts to get it moved in this direction after the Supreme Court in overturned Roe versus Wade in the Dobbs opinion back in 2022. There's a senator named Kirsten Gillibrand. You probably have heard of her. She's a Democrat from New York. She has led the charge recently for the current president, Joe Biden, to unilaterally establish the amendment. And she's actually said, Mr. President, also order the archivist, tell her to publish this. Issue an executive order, a directive to do that, something that I encourage also. She said the president's declaration supersedes the archivist and that she, meaning the archivist, is no longer relevant. That's what Kirsten Gillibrand has said. And as we come back here on Amicus Law Review, we'll tell you more about what this significant dispute is about the 28th Amendment and how it may play out in the times ahead here on Amicus Law Review. My name is Jim Santelle. This is Amicus, a law review. We are talking about this major event in constitutional history that happened just this past year, even as we anticipate the inauguration of the next president of the United States of America, hours away now in our nation's history. The United States Constitution, up until arguably just like this past week, had 27 amendments. Joe Biden articulating his view that a significant number, the requisite number of states have ratified it, and therefore it is now the law of the land. The amendment, again, guaranteeing equality for women in all facets of life, including the employment sector and other issues like housing, and of course, ensuring that all the trappings that are available to others in our life and livelihood in this country are available to women, providing a constitutional guarantee against sex discrimination. Again, that word sex, now important in understanding all kinds of anti-discrimination efforts, many of them legislative, and people often indicate that, well, gee, maybe we don't need this because there is an awful lot of legislation out there that prohibits that. The significance of this, of course, is putting it into our Constitution as a fundamental principle that will last, regardless of whether legislation is amended, is rescinded, is somehow affected by decisions of the Supreme Court. The Equal Rights Amendment was first proposed more than a century ago, has taken, admittedly, a very circuitous route to ratification, easily passed both houses of Congress with the required 2/3 vote, that's also a part of our Constitution, in 1972. And over the next a few years was ratified by the requisite number of states. But it fell short of the 3/4 of states required under the Constitution until January of 2020, when Virginia became the 38th state to ratify it. Opponents of this process, again, this is all about math, counting states and counting the time, have argued that a 7-year deadline was imposed by Congress and later extended another 3 years after that requisite number of states did in fact support this, meant that the ratification was not completed in time. And therefore, under the terms of the Constitution, it is not to be understood as the 28th Amendment. And they maintain, of course, that the deadline as it was established and then postponed by the Congress was invalid. Several states, for what it's worth, that originally ratified the amendment have since tried to rescind that approval, adding another point of some uncertainty. But along the way, as Joe Biden articulated this view on Friday of this past week, he said that he agreed with some major legal groups. Those include the American Bar Association, the single biggest bar association legal group in America. I'm a member of the Bar Association, have been ever since I was sworn into the bar of the state of Wisconsin. Many constitutional scholars have also looked at this, the legislation to extend the deadline, the number of states that have ratified in the past, and have since determined the amendment has cleared all the necessary hurdles to be formally added to the Constitution as the 28th Amendment. During this address to the nation's mayors on Friday, the president said he has consulted dozens of constitutional scholars to make sure it was all within his power to do it. Nonetheless, where's the logjam here? Well, it is with the archivist. Dr. Shogun, a deputy of hers named William Bosanko, issued a statement saying the Equal Rights Amendment cannot be certified as a part of the Constitution because of these legal, judicial, and procedural decisions that are out there, of others saying that the time period, the ratifications are not effective. The amendment itself was originally written by a women's rights activist named Alice Paul in 1923, later modified, and the amendment, again, is simple in its content, simple in its import, says equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. Interestingly, a former senator of ours has weighed in on this. He has been an advocate this for a long period of time. Former Senator Russ Feingold, who previously was a supporter of the notion that the archivist does indeed need to publish this, now taking a different view of this. He said it is completely historic to have the President of the United States say it's already in the Constitution. I believe, he said, and many believe, that whether or not the archivist certifies it or not doesn't matter. And so he joins, obviously, Senator Kristen Gillibrand of New York in saying that we do indeed have a 28th Amendment. As Senator Gillibrand and others have advocated, if there's any question in these remaining hours of his presidency, Joe Biden should do what he is doing in other areas, that is acting boldly. We'll talk in just a moment about his latest group of pardons, other things that he is doing in the last hours of his presidency. Direct the archivist to publish this. Yes, it's going to be in litigation. Yes, there are going to be challenges to this. Let the archivist know that the president has directed her and her staff to publish it and make it a part of our Constitution. It has been too long, and it is long overdue. It will be the bedrock again for future litigation. Yes, initially, litigation challenging that very action, whether or not the president has the capacity, again, under the Take Care Clause, to direct a president as an executive order, directing her to publish this. It is going to be in court, and it should be there in clarity. And so that the defenders of what the president has done can state with clarity exactly what the process has been and get this litigated. It may well end up in the United States Supreme Court. Joe Biden, in his comments about this, has said that he is disinclined to direct the archivist to publish this in the official records of the United States of America. He should do it. He should make it a part of our national history and accomplish what has been waiting to happen for well over 100 years, and that is the affirmation in our Constitution of this fundamental right to equal protection and due process and all those other things, no discrimination based upon sex in our states and in our federal government. Needless to say, this will continue to be an issue well into the Trump administration, as the Trump administration takes its own position on this. Unlikely that the Trump administration will direct the archivist to do what Joe Biden has not yet done. But all of this, again, the focus of courts. And indeed, at the end of our second hour here on Amicus, we're going to spend some time talking about what judges can do under any administration, including the incoming administration. Things that they can do not only in terms of supervising litigation, but presiding over criminal cases, and yes, indeed, criminal investigations as well, that may be initiated by any Justice Department, including the incoming Justice Department of this presidency. We're going to spend a lot of time talking about the things that judges are obliged to do, again, under the Constitution, Article 3, and the things that they have done and should do in the future as America proceeds under a new administration now just hours away. Join us for that continuing discussion here on the broadcast stations of Civic Media.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle, your host for this remaining hour of our broadcast on this historic weekend before we inaugurate a new president. Talking in this hour with you, inviting your discussion at 855-752-4842. Be a part of our discussion focusing upon the powers of the presidency, a lot thinking about the oath of office that the president is going to be taking in just a few hours, that take care clause under Section 3, Article 2 of the Constitution, and also the role of the United States Supreme Court in all of these things, in understanding and giving us opinions, sometimes very controversial opinions sometimes that are opposed vehemently by people who are also reasonable out there. Nonetheless, the role of the Supreme Court in deciding major issues. And once again, just this past week, the Supreme Court weighed in an expedited way. When it wants to work quickly, it can, and it does, in this major case involving, yes, that's right, TikTok. The Supreme Court announcing just on Friday of this past week that it would enter this new battlefield in the culture wars, if you will, and said that in the end, a congressional enactment, a piece of legislation, a law that effectively bans the wildly popular app TikTok in the United States is in fact constitutional starting this weekend. The ruling ends, at least for now, a legal battle involving national security and free speech, and again, this cultural phenomenon that has had millions of Americans swiping their phone screens throughout the days of their lives. The ruling, which forces the app quite literally to go dark. And yes, indeed, as we're on the air this weekend, the leadership of TikTok has said it is going to go dark this weekend if it remains under Chinese control. And yes, that's the national security aspect of it. Could be a death blow to TikTok's American operations. Interestingly, President-elect Donald Trump, who is, again, set to be inaugurated the following day, this coming Monday, has vowed to save the app, even though early on in the campaign, he was all on board to bring it to a conclusion. In ruling against TikTok just late this past week, unanimously, 9-0, all the justices across the political spectrum, if you will, the court acknowledged that this wide-ranging cultural impact of the app is important, but it sided with the government's concerns that China's role posed some legitimate national security concerns that Congress can act based upon its briefings about those considerations. The unanimous majority said, there is no doubt that for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, a means of engagement, and a source of community. But went on to say this, the Supreme Court did, but Congress has determined that divestiture, that is getting rid of the parent company that, according to the United States Congress and its findings of fact, has connections to the Chinese government, that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. Of course, all of this opposed by TikTok vehemently, alleging that there are two sets of First Amendment rights that are at play here that would be implicated and trounced upon if the Supreme Court were to do exactly what it now has done. There are the First Amendment rights of people who use TikTok on a regular basis. Again, hundreds of millions of people here in the United States of America who use it routinely, and an awful lot of people also saying that their businesses depend upon it. No small consideration. TikTok also maintaining that it itself has a First Amendment right to be heard and to provide this platform out there. Of course, all of this is a part of the decision by the United States Congress, very much aware of what it was doing. The United States Supreme Court then gets this on an appeal from TikTok. The United States Supreme Court telling us this: we are conscious that the cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. And indeed, Justice Sonia Sotomayor and Neil Gorsuch issued some concurring opinions that agreed with the majority's decision to support the legislation, but questioned some of the ways in which they got there. So the government had offered two justifications for the law: that China's control of TikTok allowed it to harvest these troves of private data and to spread that covert disinformation through that access portal, if you will. The court accepted only the first rationale, saying that TikTok's ownership structure gave rise to this distinctive and troubling concern. The opinion of the Supreme Court saying this data collection and analysis is a common practice in this age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. All of this, again, in the context of this major dispute. The court went on to say, we are mindful that this law arises in the context in which national security and foreign policy concerns arise in connection with efforts to confront evolving threats in an area where information can be difficult to obtain and the impact of certain conduct difficult to assess. We thus afford the government's informed judgment, by government they mean the Congress, substantial respect here. And again, the result is that the ban on TikTok in the United States takes effect this weekend on the 19th, one day before Donald Trump himself becomes the president of the United States of America. So what else do we know about this? Well, what happens next? That's the big issue. Again, the TikTok leadership has said it's going dark. And there are some options, we all assume, in the last hours here, but they're few and far between. If the law doesn't ban TikTok directly, again, as a result of the Supreme Court doing this, it will be unable to operate because ByteDance, which is the parent company here, is quite literally unable or unwilling to sell the app. Instead, and this is how it goes into effect, the TikTok authorities have said that the app stores themselves, like those operated, for example, by Apple and Google, and yes, indeed, this is very important, the cloud providers like Oracle cannot distribute the app. And that's how TikTok is brought down. For violating the law, for engaging in those operations, Apple, Google, Oracle, for violating the law, those companies could face penalties as high as $5,000 per user who is able to access the app. And again, there is no concern that an attempt to access the app, even after TikTok has gone dark, exposes any particular individual to any sort of penalties. It is the possibility of the penalties being imposed, $5,000 per user. TikTok says, again, it's got 170 million users in the United States of America alone, so those fines could indeed add up quickly. That's the enforcement piece of this. And of course, the other piece of this is purely political and purely governmental. President-elect Donald Trump, soon to be President Donald Trump, has said, again, late in his campaign, that he was changing his position and is now considering an executive order to allow TikTok to continue operating in the United States of America. How interesting is that? But again, it is unclear if that executive order could effectively halt the ban. The ban, of course, again, going into effect hours before he is the president, and once again implicating what we began our broadcast this weekend focusing on, the Take Care Clause. An awful lot of people will say, well, gee, that's the legislation of the Congress that TikTok is banned, rightly or wrongly, based upon these security issues. Again, not dismissing the First Amendment issues, but the security issues greater than that. That's the determination of the Congress, now upheld by the Supreme Court unanimously. And the president has, under the Constitution, the obligation, yes, indeed, to take care that the laws of the country be faithfully executed. That will be the argument in opposition to Donald Trump doing anything to try to stop this. Legal experts have also said, of course, that he could direct the Justice Department not to enforce the law. Those are the folks who would enforce these penalties against Apple and Google and Oracle and others out there for attempting to sell the app. Again, the question comes whether or not the Justice Department has that authority raises the larger issues that we've also discussed a lot on this broadcast about who is in charge of the Justice Department. Now, plainly, the Attorney General himself, likely the Deputy Attorney General, Lisa Monaco, will be resigning, if they have not already, as this broadcast goes on the air. And there will be other acting Attorneys General and acting Deputy Attorneys General, acting Assistant Attorneys General there to keep, more than keep the lights on, to keep the operations of government going. What is the issue? What is the relationship now between a White House and the Department of Justice? Will Donald Trump call those acting folks before Pam Bondi is confirmed by the Senate and ask those people or tell those people that they're not to enforce the law? Is that consistent with the take care clause? Is that the kind of thing that we want? Is that acceptable in our basic understanding of the norms between the White House and the Justice Department generally? This TikTok issue, important plainly in terms of First Amendment issues, commercial issues, those people who rely upon it for business. It's important to security issues and international issue. But yes, indeed, it is perhaps one of the most important quick decisions that the Supreme Court has made this term, 2023, 2024, 2025, in recent years, one of the most important decisions it has made, because it also underscores the significance of the relationship between the presidency and the Department of Justice, the loyalty of people who may be there, the importance of applying the take care clause, the responsibility that the president has to faithfully execute the laws, in this case, to ensure that TikTok is not operating in violation, in compromise of our national security. Lots and lots of questions. Plainly, again, like other issues related to things like the 28th Amendment, going to survive not just the Biden administration that has said it's going to leave all of these issues to the incoming president and the Trump administration. All of these things going to expand both the Biden administration into the Trump administration, not going away anytime soon. Instead, going to be a part of our national discourse, our national discussion about constitutional provisions, including the First Amendment, including the security of our nation, including the powers of the presidency. All of that continued as a part of our discussion here on Amicus, a law review. My name is Jim Santelle. This is Amicus, a law review. Once again, honored and pleased that you have chosen to spend some of your weekend talking about these major issues as we are on the cusp of a change in administrations in America. Lots of things going on in the area of the rule of law, including arguably an amendment to our Constitution, adding a 28th Equal Rights Amendment. A lot of things having to do with TikTok as well that will continue to be the focus of community discussion, but also litigation in the courts. The Supreme Court, of course, also entertaining other oral arguments just this past week. Let's talk about some of those. The Supreme Court right now has about 56 cases on its docket. We'll probably add a few more of those before it rests, if you will, with a number somewhere in the 60s. Likely that's what it's done recently. Sometimes gets into the 70s. And likely that all of the cases, including the 4 cases that it heard oral argument on this past week, will be decided in the weeks, months ahead, most often in May, June, sometimes even in July of the year. And so this past week, a number of cases, all of them on the 13th, 14th, and 15th, Monday, Tuesday, and Wednesday, the Supreme Court very busy in entertaining these oral arguments. First case involving Hewitt versus United States. Hewitt versus United States on Monday, January 13th. An interesting case coming out of some legislation that Donald Trump signed in his first term called the First Step Act. That was a 2018 law that, among other things, reduced the mandatory minimum sentences. You've heard a lot about those when it comes to the federal imposition of federal sentences in our criminal courts for some types of federal drug and some gun crimes. The question, the issue before the court in these cases is just this, is whether the sentence reductions in that First Step Act that basically reduce some of those minimum mandatories and other things that reduce the exposure of some certain categories of drug offenders and gun offenders, whether the sentences imposed in those cases should also benefit from the reductions in the sentencing guidelines and other statutory aspects. Those should apply retroactively or not. In other words, if you were originally sentenced before the law was enacted with the lesser penalties, should you get the benefit of those laws and basically be resentenced to a lesser sentence? That's called retroactivity. The Supreme Court wrestling with that just this past week in a case called Hewitt versus United States. There's another case called Stanley on the same day. Stanley versus City of Sanford, Florida. Karen Stanley retired early from firefighting in 2018. She expected most of her health insurance to be covered under the original terms of her job. She discovered that the city of Sanford that she was working for had changed its policy for those leaving because of a disability. And Stanley, most regrettably, have the debilitating Parkinson's disease. Rather than receiving an approximately $1,000-month insurance subsidy until she turned 65, the 47-year-old retiring employee of the city was cut off after 2 years. And she has alleged that that's a violation of the Americans with Disabilities Act. She sues the city to protect her and other people with like disabilities from discrimination. It's a discrimination lawsuit. Could affect millions of Americans who retire. And again, in the midst of a disability, what is the scope of the ADA, the Americans with Disabilities Act? That addressed by the United States Supreme Court just this past week. A couple of other cases on Tuesday. Thompson versus United States, a case involving false statements that may be misleading, but not necessarily false. Can those be subject to criminal prosecution in our federal courts? A case involving Walser versus Halliburton has to do with some things called voluntary dismissals under Rule 41, a civil procedure process there. And then on Wednesday, this major case involving free speech once again, case called Free Speech Coalition versus Paxton. Free Speech versus Paxton. It's a very significant case, again, coming out of Texas, as you can well imagine from the very name of the lawsuit in itself. Paxton, of course, is the Attorney General of the state of Texas. Supreme Court hearing arguments on Wednesday in that case revolves around a Texas law. It's Texas HB 1181, requiring websites to verify the ages of people seeking adult content, including pornography. Now, some free advocates, of course, are out there saying, members of the adult entertainment industry as well, saying that this kind of thing is a limitation, an unconstitutional limitation, a restriction, once again, on free speech under the First Amendment. They're seeking to block these laws from going ahead. And they're represented, of course, by the American Civil Liberties Union, among others in that case. The litigation, the challenge, again, before the Supreme Court just this past week, again, whether or not the states can effectively implement this age verification method to limit access by underage youth. Again, a First Amendment issue, a free speech issue, but arguably also a commercial issue, right? And so the implications under the First Amendment and in other areas are significant as the Supreme Court goes ahead. Interestingly, the case less about the specific aspects of that, but more about the standard of review to apply to a law like this. While that seems very technical and very wonky, and yes, indeed, very legal, and it is, it's actually very important because sometimes the Supreme Court will say, especially when it comes to things like free speech, that we're going to apply what's called the strict scrutiny. That's the highest level of scrutiny. We're not going to permit the government, whether it's the federal legislature, a state legislature, to get by to permit them to go ahead and limit these all-important, kind of sacrosanct First Amendment rights, absent some very, very high-level compelling reasons to do so. That's strict scrutiny. And what that means, of course, is the lower courts, when they're examining laws of this sort that are said to interfere with speech, there's a very important thing in our Constitution, in our national life. They look very, very closely to scrutinize what government is doing and have to identify at a very high level a lot of strict scrutiny, whether the government has some legitimate purpose in doing this because First Amendment rights are so critically important. Standard of scrutiny, always, always hugely important here. And of course, a bit tricky here because adults are recognized to have a free speech internet right in looking at these things. And so if you're an adult, plainly the law doesn't apply to you. The courts have said, yes, indeed, you have access. That's your First Amendment right, at least under the Supreme Court's case law to this point. But the issue in this free speech versus Paxton case, of course, is what about youth? Children, do they have a First Amendment right? Well, an awful lot of people say don't have a First Amendment right at all. And so it is complicated. What the Texas law here purports to say is that we're going to verify the age of anybody who is looking at these sites, or at least the content of most of these sites, and distinguish between the people who have no First Amendment rights, that is the youth, as they argue, and the people who do have First Amendment rights, and those are adults. What the challengers are saying, of course, is that by doing that, making that distinction, again, the challengers represented by the ACLU here, the adult entertainment industry, free speech advocates, others out there, they say what you're doing is you're interfering with the adults who do have First Amendment rights. And that's inappropriate. And that is unconstitutional. Fascinating issue once again. Again, a lot of the Supreme Court decisions these days affecting free speech rights in America. We'll hear more about that, to be sure, in the spring and summer of this year. As we come back here in Amicus, more on what is on the docket of the Supreme Court in 2025 and beyond. Stay with us. This is Amicus, a law review. My name is Jim Santelle. We are continuing with our discussion of the United States Supreme Court, as we often do. Lots of things going on that are going to already have affected our lives and livelihoods here in the United States of America. The Supreme Court right now at 56 cases altogether, still accepting new cases as it goes forward in this term, including just late this past week, Supreme Court announcing that it's going to enter yet another one of these culture war areas. It agreed to decide whether the Constitution of the United States of America guarantees parents of students in public schools the right to have their children excused from classroom discussion of storybooks featuring LGBTQIA characters and themes. Montgomery County Public Schools, Maryland's largest school system, had adopted a new curriculum in 2022. It included, its lawyers said in its application to the Supreme Court, a handful of storybooks featuring lesbian, gay, bisexual, transgender, or queer characters for use in the language arts curriculum, alongside many books already in the curriculum that feature homosexual characters in traditional gender roles. That, according to what the petition is from the school board. In the past few years, of course, the Supreme Court has wrestled a lot with the role of religion, and including many things involving the rights of gay rights in our society. Recent cases, the court has ruled, as you recall well, in favor of a web designer who said she did not want to create sites for same-sex marriages. Supreme Court ruled in favor of a high school football coach who said he had a constitutional right to pray at the 50-yard line after his team's games. Also in favor of a Catholic social services agency in Philadelphia that said it could defy city rules and refuse to work with same-sex couples who had applied to take in foster children. Lots of cases in recent terms addressing the interplay between religion and LGBTQIA rights. And again, back in the United States Supreme Court on this case as well. The school system in this new case, which comes out of Washington's suburbs, at first gave parents notice when the storybooks would be discussed, along with the opportunity to have their children excused from those sessions. But the school system changed that policy, permitting excuses for the students. The lawyers said the growing number of opt-out requests gave rise to three related concerns: high student absenteeism, the infeasibility of administering opt-out classrooms in schools, and the risk of exposing students who believe the storybooks represent them and their families to social stigma and isolation. A lot going on there, a lot to unpack. Again, the Supreme Court going to decide whether there's a constitutional right, whether the school system is right in its policy, now changed, permitting this opt-out, previously permitting this opt-out process. Constitution guarantees the rights of parents to have their children excused from the discussion of LGBT issues and characters in a school setting. Again, important issues before the Supreme Court. We know that in the coming week, the Supreme Court is going to be taking up more cases. One of them, again, in the administrative area. A case called McLaughlin Chiropractic versus McKesson. This is once again one of those cases involving the administrative state, which has been the subject of an awful lot of focus by the Supreme Court. This one has to do with whether or not the FCC acted properly, whether or not the courts should defer to the administrative agency's legal interpretation of certain laws. Yes, indeed, that issue is back again, being argued in this McKesson case on Tuesday of this coming week, right after Inauguration Day. On Wednesday, a law enforcement case. This one involving something called the moment of threat doctrine, having to do with how our police behave in connection with intersections of police activity and law enforcement, safety and security, and actions with respect to particular members of our community. Moment of threat doctrine, a law enforcement matter, a criminal law enforcement matter, appearing in front of the Supreme Court this Wednesday in a case called Barnes versus Felix. In connection with all of that, of course, we've got other executive action that is not subject to judicial review, as we know. We've talked a lot in this broadcast about the powers of the executive to act under Article 2, various sections of that article, including, of course, one we haven't discussed yet in this broadcast, and that is the power of the pardon. We know that Joe Biden has done a lot of this in recent times, and indeed on Friday, the same day that he declared his position that we have a 28th Amendment to the Constitution, he also announced that he would commute the sentences of nearly 2,500 inmates who are serving long prison terms for, once again, non-violent drug offenses. That's the broadest commutation of individual sentences ever issued by a United States president. Again, what is a pardon? A pardon is forgiveness. It is an extension of largesse, and it basically wipes away the criminal judgment. A commutation is a reduction in the sentence that is imposed, either to time served, to some other period of time in prison. It is a reduction, but does not eliminate the judgment itself. President Biden said this action is an important step toward righting historic wrongs, correcting sentencing disparities, and providing deserving individuals the opportunity to return to their families and communities after spending far too much time behind bars. Of course, the clemency powers, we've seen that a lot by this president and other presidents as well. He's also commuted the sentences of nearly all prisoners on federal death row. Interestingly, two of them declined to accept those commutations. That's significant because, once again, it comments upon the pardon authority and the fact that someone who is being granted a pardon, granted a commutation, can indeed refuse that commutation or that pardon. And that's setting a single-day record of 1,500 commutations for those involved in some home confinement during the pandemic. That's another aspect of what the president did, a single-day record up to that point of 1,500 commutations for those people who moved to home confinement during the COVID pandemic. The president has said that he's considering additional pardons, and we'll see what those are in the remaining hours of his presidency. These latest commutations actually relate back to that issue that we talked about earlier in that Hewitt case that's, again, before the United States Supreme Court, the oral argument of just this past week. Here again, having to do with the imposition of federal sentences for people involved in non-violent drug offenses. Joe Biden said that these commutations would help those who receive sentences based on these now discredited distinctions between crack and powder cocaine. You remember this debate from years ago? Or face some inflated charges for the drug crimes he is trying to remedy in the wake of our better sense of how to administer the laws, the kinds of things that we should do with respect to people involved in non-violent drug crimes. He said that his statement was following the lead of Congress. His action here, following what Congress has already done, which over the past 2 decades, in doing things like passing the First Step Act, doing other things to remedy this decades-long disparity involving tough-on-crime laws, including things like mandatory minimum sentences. This issue related to crack and powder cocaine has also been involved in race. And there are an awful lot of people who identify the statistics that show that because of the distinction inside the law between sentences for crack as opposed to powder cocaine, because of that, people of color are inordinately given higher sentences than people who are not of color. And again, that is a part of the initiative by our current president to address racial issues inside our sentencing practices, commuting the sentences of nearly 2,500 drug offenders, again, aimed at inmates who received harsher sentences based upon these old disparities in the drug laws. Greatest commutation of individual sentences ever issued by a United States president just this past week. And then we also go back to the incoming president himself. And that is the major issue having to do with the now dismissed cases against him. At least one of them also the subject of this major report by the special counsel. His name, you may recall well, is Jack Smith. He has concluded not only his term of service as the special counsel, his term with the Department of Justice. He has left the Department of Justice, but not before issuing, through the Attorney General, basically authoring two reports, one of them on what he would have prosecuted, what the trial against Donald Trump would have shown if indeed it had gone ahead and proceeded before Tanya Chutkan, who was the district court judge there in Washington, D.C., was presiding over that insurrection case, that election interference case. Jack Smith, as a part of his commission, the legislation establishing special counsel, issued 2 volumes of a report. The first one on that insurrection, that election interference prosecution, now dismissed, describing what he would have presented. The second one, not yet released by the Department of Justice, having to do with what that prosecution would have shown in the Mar-a-Lago documents case, the classified documents, other documents to which Donald Trump was not entitled. The Attorney General just this past week releasing the first volume of those 2. He should release both of them as a part of his role as our chief federal law enforcement officer. That obviously a subject of continued focus between administrations as the Biden administration becomes, if you will, inside the White House, the Trump administration. But we do have the special counsel report of just this past week saying that the special counsel, the Department of Justice, stands fully behind the merits of that interference prosecution. And it basically is an extraordinary rebuke of the president-elect Donald Trump as he takes the oath of office just hours away. This is what the special counsel wrote. He said, the department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the office stands fully behind. That's a way of saying that he, Jack Smith, the Department of Justice, the Attorney General, compelled by virtue of this, I would offer, anachronistic policy that mandates that the Department of Justice not prosecute a sitting president. Jack Smith writing that our view of the Constitution and that policy prohibit our continued prosecution. That's the reason why this case has not gone ahead. Yet, he goes on to say this, but for Trump's election and imminent return to the presidency, the office assessed, meaning the office of the special counsel assessed, that the admissible evidence was sufficient to obtain and sustain a conviction at law. So what are some of the big takeaways from this report? Again, the final word on this prosecution, now dismissed, coming out of this report. Well, we know a number of things. 250 people who were a part of the grand jury system, they appeared and provided testimony. Grand jurors, 55 witnesses before the grand jury, 200 of them interviewed during the course of this investigation. Some, of course, after lengthy battles over things like executive privilege, about which we have spoken at great length. Jack Smith said that the work of the House committee that separately examined the Capitol attack was only a small part, interestingly, of the office's investigative record. Here's the big takeaway. In what amounted to the report's most important finding, Jack Smith asserted that he was confident that his team of prosecutors and investigators had amassed enough evidence to convict Donald Trump if this case were to go to trial. The report spent about 30 pages altogether, recounting in great detail how Donald Trump engaged in multiple conspiracies. Much of that, of course, is already in our public view through the indictment of the case. There was that lengthy evidentiary memorandum that we also know well that he filed in October, part of the fallout from the Supreme Court's ruling on immunities. But Mr. Smith, Jack Smith, went on to say that the office, the Department of Justice, stands fully behind both the strength of the government's proof had we gone to trial and the merits of the prosecution. Despite those major setbacks in the 2 years of this prosecution, he is sticking by the core allegations leveled against Donald Trump. He says the through line of all of Donald Trump's criminal efforts was deceit, knowingly false claims of election fraud, and the evidence, he wrote, shows that Donald Trump used these lies as a weapon to defeat a federal government function foundational to the United States democratic process. Of course, he was talking about the counting of electoral votes as a part of our Constitution. Those are no small words. He said, indeed, but for Donald Trump's election and imminent return, this case would have gone to trial. And the report is very clear, not only on the evidence that would have been presented, but the strength of that evidence to present to a jury, again, never impaneled. We will never see the light of day in that context, but confident that a jury would have found beyond a reasonable doubt the offense conduct alleged in that 4-count indictment. All of that a part of the presentation by Jack Smith in his important issue here. And so beyond that, the report also goes on to say that the Capitol riot itself was a part of what the former president, was responsible for, reflecting the strength of the First Amendment protections for free speech. Smith said he never explicitly accused Donald Trump of inciting the riot by his supporters at the Capitol on January 6th. His indictment and the other court filings put a heavier emphasis on Donald Trump's actions in the weeks and months leading up to that attack. All of that very important as a part of the understanding of this report that was just issued just this past week. He also identified along the way a huge amount of focus here having to do with the targets of the investigation. In many corruption and conspiracy investigations, Jack Smith said, the target of the inquiry is often able to wield influence over witnesses or raise legal obstacles that stymie the prosecutor's ability to get evidence. He said that Donald Trump was particularly a difficult subject of an investigation, given his political and financial status and the power to command attention, especially on social media. Acknowledging that his team devoted enormous amounts of time consuming litigation intended to prevent witness intimidation, and giving Donald Trump extrajudicial comments, those extrajudicial comments he was making, sometimes of a threatening nature about the case, an awful lot of focus that he was required, therefore, to follow up on. The special counsel, of course, also described in great detail all of those court fights that were both in the public domain. And finally, he also defended his term in office and defended the team as well. He said that his professionals surrounding him, a decidedly very committed group of people of great decency, the highest personal integrity out there, who endured not only intense public scrutiny, but also threats to their safety. All of that as a part of the report issued by Jack Smith just this past week. When we come back here on Amicus Law Review, more about the courts in America and what they can and should be doing in the days and weeks and years just ahead. This is Amicus Law Review. My name is Jim Santelle. This is the last segment in our pre-inauguration broadcast. We, of course, will continue to follow all of these issues, including these issues of the important report issued by Jack Smith, special counsel, just this past week. Among other things, talking about the professionalism of his staff, talking about the strength of the evidence against Donald Trump, and saying without equivocation that had that case, that interference case, gone to trial, Donald Trump would have been convicted for violations of federal law in connection with the indictment returned against him. No small thing to keep in mind as our president is inaugurated. Of course, he is also, as we know, based upon the judgment entered in the Manhattan trial court, the criminal court there by Judge Juan Merchan in Manhattan in New York. Donald Trump remains a convicted felon, even though these other federal cases did not go to trial, even though that state case in Georgia, plainly, probably not seeing the light of day anytime soon, even though those cases did not result in a judgment, that one did, the one in Manhattan. And so Donald Trump goes into the presidency as the first convicted felon in our nation's history. Jack Smith telling us that had these other cases, or at least the one involving election interference, gone ahead, he would have also been convicted of federal offenses for his involvement in attempting to throw the 2020 election in an opposite direction. All of that leading to our final comments of this broadcast, and that is something we began to talk about many weeks ago, and that is, what are the guardrails? What are the standards that all presidents need to abide by? Yes, indeed. There is that all-important take care clause of the Constitution that should be the source of restriction, some limitation, some observance, if nothing more, by any president who is required to faithfully execute the laws. But what about these concerns that are still out there? President-elect Trump has recently once again threatened to lock up political foes, like Liz Cheney and Adam Kinzinger on the campaign trail. He said repeatedly that we encourage the Justice Department and the FBI to go after his enemies. His picks for Attorney General, her name is Pam Bondi. She got her review before the Senate Judiciary Committee just this past week. FBI Director Kash Patel designee have also echoed those remarks. And there may even be an enemies list out there, including Christopher Wray and General Mark Milley, all of that raising again the issues of what could happen as a result of that notion of going after political foes, people who have been opposed to you in the past. And the focus, of course, should be upon judges. We spent a lot of time here on Amicus talking about the role, yes, of Supreme Court justices, but also appellate court judges, and especially district court judges. The impulse, of course, beyond leadership at Main Justice and in Washington, D.C. from the White House may well trickle down to the district courts themselves. Again, we know that the president is going to be likely dismissing, as every president does, the current Biden U.S. attorneys. Many of them are already leaving those positions. He will appoint new U.S. attorneys. They will be subject to Senate judiciary review. And they will be responsible in many ways for pursuing, if indeed this inappropriate and unconstitutional and violative of our basic norms approach to go after political rivals is in part of the president's agenda. Those U.S. attorneys will have some significant questions to ask themselves about whether or not they will be a part of that process. But if indeed the United States Department of Justice, whether through U.S. attorneys or prosecutors at Main Justice, decide to pursue investigations, there are limitations. There are restrictions. There are guideposts along the way. Suppose, for example, a federal district court judge is asked to sign off on all sorts of things: an eavesdropping warrant under Title III of the federal criminal law, a search warrant for the review, the entry into a home, a building. All of that has got to be reviewed by federal district court judges who've got to be able to assess whether or not there is probable cause. We're going to talk more about the role of judges in this coming administration, in all administrations, in future editions here on Amicus, a Law Review, anticipating again a change in administration and the importance of the enforcement of the rule of law across the board for all Americans. Have a good week, everybody.